So good morning, everyone, and thank you for joining us this morning for our webinar in conjunction with FitzGerald Legal and Advisory on the practical considerations for the Small Companies Administrative Rescue Process, or SCARP as it has become known. I'm Dee Moran and I'm the Professional Accounting Lead in Chartered Accountants Ireland, and having worked myself in insolvency for many years, I have to say I have a keen interest in this new process. So we'll firstly just a quick recap on what's included in SCARP, and then we'll spend the majority of the hour answering questions on the various topics that we think will be of most interest to you. And please feel free to send on any questions in the Q&A function, and we will answer as many as we can. But please just bear in mind that this is new legislation, and therefore we may not have all of the answers at the moment. And it is interesting to note that the first appointment of a process advisor under the legislation happened a couple of weeks ago. So I think we will be watching with interest on that one, and certainly as more of these happen. So just a very brief intro into SCARP. It commenced on the 9th of December last year via the Companies Rescue Process for Small and Micro Companies Act 2021. And essentially it inserts the process into a new Part 10A of the Companies Act 2014, and that is what has given us our process, or SCARP. It is aimed at small and micro companies, and like these are pretty much 98% of all of Irish companies, so very important process for them. And it allows viable companies experiencing temporary financial problems to restructure with the agreement of creditors. And I think it has been called for and is seen as an alternative to examinership. And the process does mirror elements of examinership, but it is much more simplified, and therefore it should reduce or have no court involvement, making it both potentially quicker and more cost effective. We can just go to the next slide, Conal, please. So in terms then of the criteria, so the criteria for it are the company must be unable or likely to be unable to pay its debts. There must not be a resolution there or an order to wind up the company. The company must not have been in an examinership for the previous 5 years. And then just to look at it, it is quite similar to examinership, but there are some notable exceptions. One is excludable debts, and we'll hear a lot more about that in the Q&A function. It is a much shorter time frame, 49 days to have an approval, and then 21 days for objection, so 70 days in total. And essentially application to the High Court will only happen with good reason. So if we could have the next slide there, Connie, please. So just then in terms of the SCARP process itself, so this just gives you an indication of what it is. So it essentially involves the company directors, they both engage a process advisor and they prepare a statement of affairs. So that kind of kicks it off. Process advisor then reviews that statement of affairs and he confirms that the company has a reasonable prospect of survival. So within 7 days then, the directors have to meet to formally pass a resolution to appoint the process advisor. And at that stage then, the advisor will review the company, complete the required notifications, request submissions of claims from creditors, etc., etc. They then use that period to draft a rescue plan, and if there are excludable creditors, well then they need to be notified if their debts are going to be compromised. Process advisor has 42 days to come up with the rescue plan, and then has to place it in front of the creditors by day 49. So he has to give 7 days notification, so he must send out notification to the various classes of companies, creditors and members at that stage, and day 49 hold a vote for its approval. And the process is approved when one class of creditors vote with the majority of at least 60% in number and a simple majority in value. And if that happens, then the plan is approved. Creditors then have 21 days to object. And if a creditor objects, then the process advisor has to go to court to seek their approval. But if there's no objection within 21 days, then the rescue plan becomes binding. Next slide there, please. Thank you, Conal. So this is just to put it out in a timeline. So just day kind of 1 to 28. All that appointment happens, statement of affairs, process advisor starts the preparation of the rescue plan. The excludable debt has to be notified by day 35. And then the meetings must be called by day 42 to give that 7-day notice requirement. Then have your meetings for approval at day 49. If it's approved, then you then have your 21 days for no objections, which does get you to day 70. And just to say, if there are objections, the court, in considering the plan, will approve it unless it is seen to be inequitable or unfairly prejudicial. So that's a very quick whistle-stop tour around the SCARP process. So I'm now just going to turn you over to our panel and just give you a very brief summary of those. So we are joined today by David Swinburne and Sinead McNamara from FitzGerald Legal and Advisory. And David is a chartered accountant who advises on the SME sector, and he holds an insolvency cert, so he can act as examiner, liquidator and receiver. Sinead is a solicitor. She advises both companies and institutions and insolvency practitioners, and she's been the Cork County Sheriff since 2013. Lilian Halpin works with myself here in the Institute, and she has a legal background, having qualified as a solicitor, and she has many years' experience in the corporate banking and restructuring area. And Conal Kennedy, many of you will know, he's our head of practice consulting here in the Institute, and he and his team provide lots of advice and support to practices and publish a range of practice toolkits. So I'm now going to hand you over to the panel, and I will see you after the session. Thank you very much.
Thank you, Deirdre, and good morning, everybody. And David, could we go to you first and ask, how can a business prepare for a SCARP?
Yeah, morning, Lilian, and morning, everybody, and thanks for having me. Yeah, I suppose Dee mentioned there early on about viability. So in terms of preparation, the first key thing is viability. Because in a process like this, you will only enter it if you know you have a good chance of exiting out the other side. And you'll only go into it if the business is viable in the first place. So if the business has a good core, solid undertaking that is worth saving, well, then it's something it should look at. I suppose the other thing about going into the process is you want to come out of it. So therefore you need funding in order for the process advisor to actually formulate the scheme and for it to be implemented. But there will also be an element of funding required to spring forward the entity. So in terms of preparation at a very early stage, and the whole thing is, fail to plan, plan to fail, it's very much looking at those two key ingredients. Is viability, because it is all about viability. And if you do go in, are you likely to come out the other end? So that's the two key things. Because again, as Dee outlined there, once the formal process starts, there's actually a very short time frame, and there's lots of activity to happen within that. But at the outside, if the key things aren't there, it won't happen. So therefore, looking very early on in terms of projections, robustly looking at them, having them challenged, go and talk to your funders, be your existing funders or new funders, and looking at all of that. Again, too, as Dee said, in terms of one of the key things at the start, that a process advisor will be looking at in conjunction with the directors and the directors' advisors is the statement of affairs, looking at the profile of the debt in the balance sheet and the mix of that debt, and are there any complex creditors in there that might need to be dealt with. So I suppose the key thing is viability and funding at the outset are going to be there and available.
Thank you, David. And how practical do you think, David, that the SCARP process is going to be for the small and micro companies to use successfully?
Yeah, good question. And again, just to outline, the first case has commenced, so we will be all watching the outcome of that to see how it does go. And I suppose the legislation is live now for 2 months. So we've had one case in 2 months. I don't really know yet what that tells us, because we have had the Christmas period and we all like to have downtime, and we've had that particularly over what we've had for the last 2 years. And then we also had a month there of another lockdown. So how practical and will it be used, it remains to be seen. It will be used if it does do what's envisaged to do, okay? And if you do have SMEs that can't afford, not necessarily purely from a cash perspective, but from the business perspective, to cease trading, well then it is something it should look at, okay? Because if it needs to keep trading in order to really remain viable, well then it is something you should look at. But that will be done in conjunction with the overall cost, because SMEs, and I suppose while the criteria here is quite broad in terms of looking at turnover up to 12 million and a balance sheet of 6 million, when we're talking about small and micro companies, they will be very cost sensitive. So I think the overall cost of the process will be something that will need to be borne in mind. So in theory, yes, it is suitable and will be suitable and successful for small companies, because traditionally these companies would go into liquidation and fold. So it is a viable option for them to consider and look at if have the key ingredients there at the outset.
I wonder, David, though, good morning everyone. I wonder, will we actually see the full effects of this legislation until the supports that are currently in place are gone? So EWSS, it's still there, it's dwindling, but it's still there. And maybe with warehousing extended until the end of March next year, maybe we won't see the full effects of this legislation, the full benefits of it, until the current supports are removed in their entirety, because they are supplying a lifeline for a lot of businesses at the moment. So maybe when they're gone, we'll really see the impact of this legislation.
Yeah, we will, because there's nobody putting anybody under pressure at the moment for cash. So once the supports, like Sinead said, go away, that's when they'll be all scrambling, where's the cash going to come from? And that's when the pressure cooker will start to go into being.
Indeed, yeah. David, you mentioned there about the small and micro companies, and that's obviously one of the eligibility criteria. I think there's 98% of companies fall into that criteria. But what other eligibility criteria should a company look to when it's considering the SCARP process?
Yeah, I mean, so eligibility outside of that is really much around viability, so if the company has had a long history of being loss-making, well then the prospects of it being viable into the future are very slim. So therefore, while it might meet the formal eligibility criteria, it doesn't meet the real eligibility criteria in terms of entering and coming out the other side. So if that is the case, well then SCARP is not going to be an option for it. Like historically, it has been loss-making. That's unlikely to change. And we are in challenging, difficult trading times anyway, in terms of disruption technology has caused to businesses. How we work, the way we work is changing. So there's capital requirement constantly required for that too. So historically, if it's always been loss-making, well then the reality is, SCARP won't be for it.
And what advantages and disadvantages, more importantly, I suppose we've seen a lot of writing about the, articles about the advantages of it. Maybe you could touch on those, but also the disadvantages of entering into the process.
Yeah, and I suppose, again, Dee had mentioned examinership, it has been around a long time. So the similarities in terms of the pros and advantages for SCARP would be similar to examinership in that the company does continue to trade, as it doesn't cease. That means that the employees continue to work, and it continues to earn cash, and cash will be, as we know, is king, and will be king in terms of trading during the period while it is in the process. It does allow for what's envisaged. The outcome of this is that a balance sheet, that will be right sized in terms of, it does allow for debt to be written off and crammed down. It does also allow for the repudiation of property leases and other onerous contracts, and that probably come up again, because that's something that does come up a lot even in examinership case. So it does allow for that once that can be done in a consensual manner. And I suppose one of the overriding advantages is that, and similar, different to examinership, is that it is to be much more cost effective. And I suppose that's what this is envisaged to be attractive to companies, that there isn't going to be the need for, or should not be the need for, extensive court involvement, And I suppose the other key thing, this first examinership, it is the shorter time frame, because again, too, if you have the key ingredients of viability and funding, you want to get in and out of this quite quickly and move on. So that does allow for this, and so the much shorter time frame is also, I think, a key advantage for this particular process. I suppose in terms of disadvantages, I suppose if you do go into the process and it is unsuccessful, well then the company will be faced with liquidation and potential receivership if it is got fixed charge security in there. I suppose there is also the risk that you do get to the end, day 49, and following that, where with the 21-day period, somebody does object to it. And if you do have the objection, well then, you're into court, which involves an increased cost and further uncertainty brought into the mix. There's no doubt that this process will have a negative impact on a business, because in some ways, when insolvency just naturally does, so that just needs to be borne in mind in terms of the trading with his partners and customers and stuff like that. But again, too, in terms of the planning phase, as part of the planning phase, you look to put a plan in place as to how you're going to deal with that anyway, and approach and talk to those particular customers. Again, too, if you have a balance sheet which is complex in terms of potentially having lots of onerous contracts and maybe some large difficult creditors who are likely to object, well, this isn't going to work. So therefore, they may at the outset to consider examinership as opposed to this. I suppose we also do have the excludable debt, which could very well be a challenge, and I think in any scheme, the revenue is going to be a creditor. Again, too, the revenue will only be excluded if it has grounds on which to do so. So while it is in there, it's not going to be all and end all, but it's just something that people are considering in terms of the impact that might have, so I'd see those as the key.
Yeah, and I think that, sorry, Sinead.
No, you're fine, Lilian, work away.
Yeah, I think that it goes back to your point initially, David, where you said you need to plan and recognise that they're going to be disadvantages, and try and see, can you deal with them before, as part of the initial process before you actually go into it, So I think that Conal, you have a general question in this area now, so I'll pass you over to Conal for to ask that question. Thank you, Conal.
Thank you very much, Lilian. Good morning, everyone. Yeah, I mean, obviously this is a very important piece of legislation. It's going to have far-reaching impacts. And I'm thinking of the situation from the point of view of the general practitioner, who isn't necessarily going to act as a process advisor, but they've got a portfolio of clients, and they're looking around this portfolio now and thinking of the impact or the potential impact of this on certain clients. They're going to have clients who are in trouble, who are struggling perhaps. They're also going to have clients who are dealing with others, who may have customers, debtors, who are in trouble. And are contemplating this as a route out. And specifically in that category, you may have they may have clients who are landlords. So obviously they need to be thinking about this. So I just posed the question to yourself, David, and indeed Sinead. What call to action would you have for those members in practice who are thinking about this and who want to pass a message on to various clients?
Yeah, I suppose that's interesting, and a practitioner could have a couple of different hats there. He could very well have a client who is vulnerable and potentially looking at this. And again, too, he's going to be very key, because again, for this to work, a lot of work has to be done well before you approach a process advisor. So he's definitely going to be in some ways putting together what needs to be done in terms of looking at obviously putting together all the financial information, looking at the profile of the creditors, to know the tricky ones, to know who the existing funders are they likely to fund the scheme, so he's the practitioner is going to be very key in terms of the early stages of this, because when they do come to sit down with the insolvency practitioner to get advice from them, that's all the information that will be looked for, so therefore they will have a key role. Again, too, you said it could be representing a landlord. So again, too, they need to give advice to that particular landlord if it's the company that it is a creditor of, goes into the process, what could be faced and what the outcome might look like for them. So
yes, and I suppose working with that landlord client in terms of presenting variations or modifications if there is a hint that the process advisor is going to seek to repudiate. So I think their advisor would work with them on that.
because again too, because that is a real risk, like that. Yes, this landlord is not consensually, if the lease does need to repudiate it, and to know that this landlord is not going to consent to this, well, you know, that's very key at the outset. Well, then this probably isn't the process for that, you know. Again, too, just generally advising their clients or customers that, okay, fine, you know, you have a huge balance here. This company is vulnerable. Therefore, going forward, you do want to reduce your exposure, so it's cash on delivery going forward, and you know the debt that there is there. You know, but again, to trying to advise them to sort of limit their exposure as much as they can.
And I suppose stressing to clients as well that the only way of getting revenue on board here is to make sure that returns are made up to date and taxes are kept current. Because if you don't have a good history with revenue, then they will exclude the debt.
Thanks very much. Some key calls to action there. Thank you. Lilian, I'll pass it back to yourself because I know you've got related questions.
Thanks, Colin. Yes, thank you, Colin. So, David, just going back to the process, and we're looking at creditors objecting to the process. There's no automatic stay like there is in examinership in the legislation. So is there a danger that a creditor will swiftly gets a hint of this, will swiftly act to exercise their rights, and that'll scupper the process or make it somewhat futile?
I suppose yes is the short answer in one way, but
I suppose yes and no. The process advisor can apply to the court to stay any enforcement proceedings that might have commenced already, or to stay receivership or provision liquidation. So there is that option open to the process advisor at the outset, but I think, you know, the process advisor would have to look at that very carefully in terms of costs and whether it's worth it in terms of, you know, coming out of the SCARP process, whether there is a very good prospect of success.
Right. Yes.
And I suppose feeding back into the previous question there from Conal in terms of the practitioner working with his client, you know, they'll know the profile of the creditors, who are the tricky characters within that, who are the ones that are likely to object, and you know if the an assessment will need to be made of that early on. So if it's likely that they are, well then obviously the process advisor at the outset needs to be aware of that, because again, like Sinead said, that needs to be factored in. Will the process advisor be making an application to court, and the implication would that have on timing? And it could very well then, if it's in the system, push out the overall 49 days, you know, so then that brings more uncertainty into the mix and stuff like that. So at the outset, try and make an assessment as to who's likely to be difficult. Now, I mean, you're not going to be able to plan for everything. So if somebody does, who was envisaged, was going to object, you know, early on or at the outset, does happen to do it, like Sinead said, there is the option to go to court, like, you know, so you won't be able to box off everything in advance. But, you know, again, if that does happen and there is application required to court, it just brings that uncertainty, more uncertainty into the mix.
But I suppose, you know, some creditors may seek first mover advantage. So,
yes,
you know, they might try to get in there first before the SCARP process commences.
Yeah.
And I suppose if you're advising some creditors, that might be the advice. You know, if there are mutterings about a process advisor possibly being contemplated, then, you know, to move first in terms of a court application, in terms of liquidation, or the appointment of a receiver.
Yeah, and that ties in. I've seen commentary where it says that experience suggests that at least one creditor will object to the process. So I suppose it really goes back. So objecting to the rescue plan, pushing everything into the court, inflating the costs, but it really goes back to looking at the whole thing at a very early stage, doesn't it?
Yeah, it does. And then again, potentially there may very well be, you know, some creditors, high profile creditors are given who or what they are, you know, may not want to be seen to be actually consensually agreeing to things within.
And it could be a policy decision made very
early.
early.
Could have a knock-on effect on other people, other you know, clients in a similar position or whatever, you know. So,
yeah, exactly. Yeah.
Sinead, you touched there on excludable creditors and the revenue in particular, and I think this one could be one that could maybe present a challenge to the future viability of the company, especially revenue and the warehousing of debt. I did see a commentary there recently that more than 98,000 firms have deferred or warehouse tax debt worth 2.9 billion at the end of December 2021. So I think that maybe, how do you think that the excludable debt will roll in the process?
I suppose with so much debt warehoused, It's hard to envisage how this will pan out. Revenue can opt out of the SCARP process if the creditor, if the company has failed to comply at any time with the filing of returns or the payment of tax. So I suppose, you know, it's not sufficient to say, look, you know, we don't want revenue to opt out because, you know, we've been good boys for the last few months or the last few years. Revenue can look back a very long time and seek to opt out if there hasn't been compliance at any stage. Also in circumstances where there's an audit ongoing or an open investigation or an appeal, that is a ground for revenue to opt out as well. So I suppose all is not lost for companies who maybe wouldn't have an impeccable track record with revenue, you know, and they're fearing that they will opt out of this. I suppose there is a level of comfort while the warehousing is still in being, and that will be there until the end of the first quarter next year. So maybe when the directors initially and the process advisors subsequently look at it, and maybe there isn't a clean track record in terms of revenue and revenue will opt out, maybe all's not lost when warehousing is still there as an option. You know, maybe the revenue debt can be sort of parked and, you know, dealt with on a phased payment arrangement once warehousing is up. So it won't be fatal possibly to the rescue plan working, but I mean, it obviously most people will want revenue to opt into the SCARP process, but that won't be possible if there isn't a clean sheet with revenue.
Right. And
yeah, I think on that, the revenue and the excludable debt, like with all these things, that, you know, each case is different. It will be all on a case by case basis. And, you know, potentially, like Sinead said, they may very well want to, you know, park the revenue debt, it's in warehousing, and go ahead with this, you know, and do a scheme to deal with the other creditors, and the revenue will have to be dealt with down the track. Or potentially all creditors, including the revenue, need to be dealt with now from this whole viability perspective, you know, in order to move forward. Like, so it'll depend on each case, really.
But certainly once warehousing is gone, then, you know, revenue is key again, and dealing with revenue and having them not opting out will be very important for companies. So
absolutely,
you know, I think for the company's accountant, keeping compliance in order is absolutely imperative.
Yeah, indeed. And while revenue is obviously the major excludable debtor, the major excludable, there is a couple of other ones in there as well.
Essentially state debt.
Yeah, exactly. Yeah, just to clarify that. And
sorry, I just missed that one from Sinead. You might repeat that.
Yeah, it's essentially state debt, Colin. So you know, debt under the social welfare legislation, that sort of thing. So revenue and state debt are the excludable creditors.
Okay.
And Sinead, I think we touched on just a little bit earlier. We were talking about the repudiation of the owner's leases. And could you just outline for us or give us some idea about that and how that's different from, you know, the excludable debt process in the whole thing?
So basically, onerous contracts are defined under the legislation as contracts that are burdensome, or contracts that, you know, are not essential to the company going forward. So in those circumstances, the process advisor may seek to repudiate those contracts. If he gives notice that it is intention to repudiate the contracts, the other party has the option to put forward variations and modifications, and the process advisor will be obliged to take those into account and assess them. If they're viable, then maybe modifying the rescue plan, or if he deems that, you know, the modifications of our variations suggested aren't sufficient, he has the option then, if the other party isn't consenting to the repudiation of the contract, to go to court to seek ratification of the repudiation.
Right.
So typically, I think the main ones will be leases, but there are other contracts, you know, onerous contracts isn't limited to just leases. Other contracts that are no longer advantageous to the company can come into the mix as well.
Yeah, and we've seen analogies, I suppose, it's there's been a few high profile lease kind of disputes with landlords over the last few months in the, I think it's in the examinership context, was it, or So yeah, it remains to be
Yeah.
seen about these.
And there was a case there in the not too distant past too, is where a company did seek to protection, and I suppose one of the key things that was going to be involved was leases. But at the time of making the application, the company actually wasn't insolvent and did have enough cash flow to keep it going for another long time beyond that. But one of the key things just in relation to the whole interaction with landlords is the judge wanted to know, well, what interaction have there been with the landlord, and there've been very little or none. So again, to what we're talking about going into this process, he won't go into this process to have looked at and exhausted all other ways of trying to deal with this.
And I think that feeds back to the point you made initially, that it's early planning and communication with all creditors, the landlord included, to see what sort of consensual arrangements can be put in place. We were just having a discussion recently in terms of commercial property, that had been thought, with the pandemic, that the demand for commercial property would fall. That's actually not the case. So it may not actually be as difficult to obtain a consensual repudiation from a landlord as might have been thought previously. But I think it's very important to get as much groundwork done as you can with the landlord and other parties to onerous contracts, because really, I think for these rescue plans to work, the last place you want to be going to is court, in terms of the cost implications.
Yes, indeed. Yeah.
Okay.
Conal, I think you have a couple of questions on this area, so I'll pass over to you to ask those now.
Sure, yeah. I mean, I just thought I might try to distill what we've covered so far into a practical question, practical sort of case study where, a not unusual situation where if you want to call it company A is dealing with company B. Company A is the seller, company B is the customer, debtor, and a trading balance has been allowed to build up, perhaps due to the pandemic or whatever, and it's got out of hand, and there's quite a substantial trading debt has built up. Company A gets wind that Company B is contemplating going to a SCARP process. I mean, is this good news? What courses of action are open to Company A when they understand that their debtor is doing this? What should be thinking about? What's their next? What do they need to do under time pressure?
Yeah, I suppose get into the car and get down quickly to Company B, and I suppose take your mask with you as well. I suppose that but the signs of these have had a long trading relationship, so and they both have been dependent on each other, and into the future, if they want to be that way too. So the key thing is for them to sit down and for, I suppose, to have an open, honest, transparent conversation. I suppose for Company A, obviously, it has accrued a huge liability. So therefore, going forward, it doesn't want that to get any worse. So it could very well say, listen, I'm only going to be supplying you now on cash only going forward, till we find out what's really going on here and what you're actually going to do. And then the other thing then too, in terms of Company B, if it is going to be going into a process like this, it will want the support of Company A, because chances are it's probably going to be one of its biggest, largest unsecured creditors, and will probably be in a class with lots of other unsecured creditors. So it will want to bring them on board in turn to help bring all the other unsecured creditors on board, I suppose these type of relationships have their own different nuances, but again too, it goes back to the key thing here is relationships, and they are very important to each other, because even the guy that's owed all the money doesn't want the tap to stop straight away, because then he won't have the cash coming in, which in turn will lead for other complications for him. So if he knows that going forward, I'm only going to do cash only, at least you know what's coming in, and I'm only going to supply in that base, that separately Company B will know that. It might also help Company B crystallize quicker what it is going to do and what it does need to do, because again too, if it is insolvent and companies continue to trade while insolvent, that brings on a whole other layer of complications for directors, So for practical terms, it's get down and try and find out. Now it can be difficult then a little bit for Company B to be maybe as open and transparent as they'd like to be, because they could very well have all other creditors and complications to deal with, but I suppose the key thing Company A is to draw a line in the sand in terms of the debt creeping up and the cash only in the short term, because that's in reality what would happen during a rescue process anyway, is that creditors, once they know this is happening, will want to be getting cash, so they know that their exposure isn't. Yeah.
Very good. Okay, well look, that's obviously an urgent course of action to be taken in those circumstances. The other kind of situation which I thought was likely to be quite common going forward is a company which had once again a difficult pandemic, and were closed down for part of it, and basically kept going. I don't know, perhaps through government supports, whatever, but have been warehousing tax debt, and that is their major issue. Is this very substantial balance of a warehouse debt. They've reopened, they've returned, if you like, to day-to-day profitability, so they don't really have issues besides this very large warehouse tax debt. So is this process going to be of use to them? You mentioned earlier about revenue perhaps not coming into it. So is this not relevant to that particular type of debtor?
It could be.
No, absolutely could be, and the need to look at it. I suppose the first thing again just is in terms of the viability question. Okay, it has racked up this, let's call it by the sound of substantial debt in the last 2 years and predominantly revenue. Okay, so but the key thing is going forward, just parking that for the moment, is this entity viable? Because this is all about reasonable prospect of survival and viability and saving enterprise and jobs and all that. So if that is the case, well then yes, it should look at this process. If the revenue debt, if there's no grounds on which the revenue can be deemed to be excluded exactly and opt out, and that it has no option but to be included, and the debt would need to be dealt with then in terms of the scheme, and I suppose just the interesting thing that's coming up when we do talk about revenue and excludable debt is in terms of warehousing has been gone for 2 years now, so there's 2 years of warehouse debt. But normally we look at in some situations for revenues preferential status, you have a 1 year look back period, which would be preferential, and the balance there unsecured, and therefore normally preferential creditors and unsecureds are in different classes and get different dividend levels. So I suppose the thing is, if there's viability there, well then yes, it should look at the process, and the fact that there is a huge revenue debt there should not make them run away from this particular process.
Particularly where they have a clean sheet. But I suppose again, Conal, this, I think a lot of companies and businesses are sort of putting company debt or putting revenue debt to the back of their minds for the moment, and they're able to do that because of warehousing. So I think, at the end of the first quarter next year, the focus will be on revenue debt and what sort of arrangements can be made. And I think for some, the debt will be so extensive that the mountain will just be too high. And at that point, I think, again, companies, particularly who've had a clean sheet in terms of filing and paying, will go down this road because they won't have any other option.
Okay, that's we'll have to wait and see, I guess.
And you have to wait and see that, and like there's 100,000 of those companies, in that sort of situation, have the warehouse debt. They may not have. It won't be all the same situations, and sure, the nuances of each case is different.
I mean, some they're trading, they might be flying, they'll have no problem in meeting whatever installment arrangement is entered into with revenue. But for some, the mountain just might be too steep for them, and that they will look very carefully at the SCARP process.
Okay, thank you very much. Okay, I know, Lilian, you want to ask about other people involved in the
yes. Thanks, Conal. Thanks for that. David, what about employees in this process? Is there any is there any provision for them, or how do they figure in it?
I suppose traditionally, Lilian, employees are a key part of any enterprise and any organisation. So you rarely see them being included in a scheme arrangement in terms of having whatever accrued liabilities they may have been written down as part of a scheme. So it's not common for them to be, let's call it, creditors in a scheme per se. Just one category of the excludable debt where you could very well be, where you might have some former employees who may have been an award for redundancy that hasn't been paid. So that falls under the excludable debt. So they could very well be former employees, or you could have some other employees who got awards under some of the other social welfare acts. So they could very well be, but I suppose in that instance, you're talking here maybe about former employees. It depends, I suppose, again, too, each case is different. If you had those and depend on the quantity of them and number, etc., it might have an impact maybe on morale and whatnot if the company seemed to be putting, how they deal with those creditors. But in general terms, the existing employees of the company don't usually get impaired or involved. Now they do have an entitlement to get in the process that Dee outlined earlier and to be notified of and kept appraised. But again, to come back to the whole planning phase, you know, and again, to planning for a process like this, or indeed examinership, is all very sensitive. So it's usually kept within a tight view. But when it does come to it, if you are going to do it, you know, when the time is right, you will be briefing your employees and telling them what you're doing, why you're doing it, the impact it will have on them, and all that. Because even during the process, it's going to be very challenging for them, because they're going to be at the cold faced, you know, dealing with the key stakeholders of creditors, and they're going to be ones that looking to recover money from debtors and dealing with customers and all of that. But the chances of them being impacted negatively, no.
Yeah. So it's giving them notice and telling them what's going on at the appropriate juncture, and trying to make sure that they're kept on board, so that I suppose they could be key as well to success, part of a key to a successful outcome as well. So yes.
Absolutely. Yeah, absolutely. Yeah.
And Sinead, do you see any role for solicitors, or what is the role of a solicitor in the SCARP process?
There'll be a role, Lilian, but I think it will be a limited one, because this legislation was designed to keep interaction with the court system to an absolute minimum, you know, to avoid it if you possibly can, but certainly to keep it to a minimum. So I think maybe at the outset, if, you know, enforcement proceedings are in being, a solicitor may be required by the process advisor in terms of advising him or her as to the options open in terms of applying for a stay. Same if there's a receivership in being, or provision liquidation. So I think creditors may seek legal advice if they wish to object to a rescue plan. And in terms of bringing that objection before the court, parties to onerous contracts, leases in particular, may seek legal advice in terms of what grounds they have in terms of to challenge the repudiation of a lease or an onerous contract by the process advisor. So I suppose, you know, they will be, legal advisors, solicitors and barristers will be there in the background, but it's not envisaged that they would take a major role, you know, so it's not like examinership, you know, here the process advisor you know, is appointed by the directors. The rescue plan is approved by the creditors. So it's only in the case of objection really that the courts will get involved, and that then will bring in the involvement of legal advisors. And I suppose, unfortunately, that will also involve a rise in costs as well. Exactly.
And sorry, Sinead, could I just go back to when you're saying the if they'd be involved at the beginning for enforcement proceedings, do you mean if like a receivership or something? Is that what you're talking about?
Or if there were other litigation. So if a creditor had proceedings in being against a company before this process started, it is open to the process advisor to bring an application to the court to put a stay on those proceedings.
Oh, right. Yeah.
If the rescue plan a reasonable chance of succeeding.
Right. Yes. Sorry, I understand that. Thank you.
So just on that, because again, too, like Sinead said, and it's not envisaged that, you know, solicitors or barristers will be involved to keep the costs down. But, you know, maybe, and again, too, because like Dee had mentioned at the outset, this is new legislation to all of us, even though it does mirror quite a lot what's in the examinership, and we're all quite familiar with that and how to work through it. But maybe at the outset and for the first few schemes, you know, that an insolvency practitioner may, you know, rely on solicitor for advice in relation to if things do prop up in relation to certain sections of the legislation as to how to be dealt with. So from a whole learning and development at the outset, there might be a bit of involvement in that, you know.
But I think as court decisions start issuing on, you know, various stages of the SCARP process, you know, I think process advisors, you know, and anyone involved in companies and creditors will emerge, I think, quite quickly what will fly and what won't.
Sure.
So yeah, I think maybe at the outset, process advisors may need the comfort of legal advice, but maybe that will wane as court decisions issue and we see, you know, practices emerging.
Yeah, sure. David, could we just go back to the funding point that you were talking about, and you were talking about that earlier as one of the key things that you know that would make the SCARP process viable. How difficult or easy do you think it's going to be for SMEs to get funding? If you know, are they going to? Because if they can't get it, I suppose they're going to be left with their current creditors and banking that are not to be able to get involved.
Yeah, I suppose, yeah, a difficult, challenging question, but it is absolutely key. And I suppose, you know, in terms of this, like for an insolvent company by its nature, it is much more difficult for it to attract funding. You know, so therefore, in terms of, and going back to you were asking earlier on to Colin about, you know, the practitioner and the general practitioner, you know, he will have a key role at the very outset as well in terms of his client and the relationship that that client has with the existing funders and bankers, because that will be key, because invariably the current funder will be involved going forward. So therefore that relationship needs to be very good and solid and good, open, transparent communication. So yeah, it is more challenging for insolvent companies, absolutely, to attract investment. But then again, too, if you have the viability bit and that can be demonstrated, well, then it should be easier to attract that funding. Again, too, if there's some new funding coming in and new parties coming to the table, you know, again, too, they might dictate certain things need to happen and all that needs to be worked around and navigated around. Now, I suppose when we're talking here to small micro companies, they tend not to have the same complex balance sheet and they do not have sophisticated potentially asset classes. So a lot of small micro companies, you know, very much rely on working capital, cash flow type lending and funding. And there is a lot of that out there in the market, and there's lots of providers and alternative providers in that. So there are sources of funding that are there, and again too, they need to be looked at very early on to see what they are, what the requirements will be of those funders, and see can you meet that there, because again too, in terms of entry is one thing, but exiting out of this is key, and the funding will need to be in place. So there's lots of working capital funders out there. There's lots of, you know, government backed schemes via the mainstream banks that can be looked at again. We all know there is an awful lot of funding in the market at the moment, but those funders can be picky as to where that goes. And insolvent companies won't be the ones that, you know, by and large, distressed companies won't be where they want to go that. So I think you're right there, and you touched on it there in terms of the question, in terms of existing lenders and funders will be key in that. And again, too, where you have a bigger, more sophisticated company which does have different asset classes and more of a complex balance sheet in terms of secured creditors, etc., they will be key as well in terms of formulating that, and again, early communication with them and setting out the projections and the viability plan, the business plan, and what that's going to look like and how they're going to fit into the mix and that. So all that would have to be pretty much streamlined and put to bed before you actually go into a process in the first place, you know. But so to answer, yes, there are lots of sources of funding out there for small and micro companies around.
Yeah. It's interesting, the government funding as well that you read, because every week, well, certainly in the last year, every week you'd read about some. I'm not sure whether it'd be suitable for this or not, but there's certainly plenty of there was certainly plenty of government funding. So maybe just to look at that as well, maybe, you know.
Yeah, you're right. And even there in terms of the government, to be fair, have provided support and funding for the last 2 years. And I suppose, you know, going forward, that just can't fall off a cliff in terms of that way. So you do need to have some alternatives. So you're absolutely right. These alternative things could very well be applicable, because ultimately, if you have, this is about saving viable businesses. So viable businesses can demonstrate that they can be viable. They need the funding in order to make that happen and springboard forward. So yes, yeah, you could see it working.
Yeah. Okay. Sinead, coming back to the whole court situation, and if it does end up that the matter has to go into court, though I understand it's the circuit court that one applies to. So how do you see that? Are circuit courts going to be? Is there a body of precedent, or will they be able to deal with that in the locality? What do you think about that end of things?
Well, I suppose the legislation is new, so precedent is there to be set. So the legislation provides for applications under the SCARP legislation to be brought before the Circuit Court or the High Court. So it's up to the process advisor to decide which jurisdiction to go to. Now, the legislation makes it very clear that the High Court should only be resorted to if there is exceptional reason to opt for the High Court. So the legislation is very much pushing applications towards the Circuit Court. And there's very good reasons for that, because obviously the costs are lower in the Circuit Court. So any application under this legislation can be brought to a Circuit Court where the company has a registered office or where the company has a place of business. So, you know, traditionally, judges with insolvency expertise were High Court judges, but I suppose with the introduction of the personal insolvency legislation a number of years ago, that there now actually are insolvency judges in the Circuit court. So that expertise is there already. You know, it's not quite the same, obviously, but there would be insolvency expertise at circuit court level. And I suppose, interestingly, under the legislation, there is discretion for the court in some applications under this Act to have proceedings heard in private, so in camera. Generally, all proceedings are held in public except for family law proceedings. So there is a provision for a circuit court judge to exercise discretion to hear applications, some applications under this Act, otherwise than in public. And they can do so whether they think that's necessary in the interests of justice, you know, to protect the company or any specific creditor. So I thought that was interesting, an interesting aspect of this legislation.
Yes, indeed. Yeah. Wouldn't come across too often. Indeed.
No.
So I think we might have time for one more question, Sinead, or Deirdre can tell me anyhow. It's just interesting to know the process. We were talking about it earlier. It's a 70-day process, so it's quite tight on time, and that was, you know, a good thing. But say if the company gets to where it's nearly there but not quite there, and needs a little bit of an extension of time, is there a way to extend the time, or is it very rigid to the 70 days?
Yeah, there is an express provision for extension, but I think if the process advisor is looking for the extension, I think they would have to be able to justify that there is a very good prospect of this company coming out of the process successfully.
Right, yeah.
You know, I think significant positive progress would have to have been made within the 70-day period already before an extension would be granted.
Right, okay.
I suppose it's always, Lilian, ties back into the whole pre-planning bit, you know, in terms of, you know, you want to enter and you want to exit. Enter, you need to be viable. Exit, you need to have the funding. In terms of the pre-planning, looking at the profile of different creditors, who are the ones that are likely maybe to be difficult, trying to work through them, box off them, and have all that done, so that if you are going into court, it's something that propped up, was never envisaged. Yeah. This is why it came up, and you know, and we need to get over this hurdle, because it's the only thing holding up the plan being implemented. It has, you know, been approved by the body of creditors, whatever the case may be, you know.
Exactly, yeah, exactly. And so you can only use the process once every 5 years, but it wouldn't be something that you'd be using every 5 years, I presume, Sinead. That wouldn't be.
No, I mean, I think, look, if you've availed of the process already, I mean, I think the directors would have to sit down and take a very hard look at the company with their advisor, you know, and maybe liquidation is actually the route to go rather than prolonging the inevitable and seeking to go down this process again. I mean, theoretically it's possible, but on a practical level, you know, I think if you were going there again that soon, you would have hard decisions to make, I think.
Indeed. Yeah. So I have just one more question about who can act as the process advisor. So you might just outline those.
Yeah, pretty much similar to who can act as liquidator at the moment. So an accountant, practicing solicitor, member of any body recognised by IASA, I suppose, parties from other EA countries with similar qualifications, and then those people with practical experience. So very similar to what we'd have seen before in terms of, you know, people who were qualified to act as liquidators. Yeah. Having said that though, Lilian, I think the reality of it is, while all these people can theoretically be process advisors, I think in reality we're going to see the experienced insolvency practitioners are going to be the people who will take on the role of process advisors, particularly in terms of, you know, the legislation imposes very strict timelines. So I think you would want to be fairly au fait with processes such as this before you would take it on.
Yes, indeed, and be familiar with the whole precedent from other areas as well.
Yes, the rescue plans, schemes of arrangement, that sort of thing. Yeah,
exactly.
Yeah, exactly. That's it. Because like that too, because it is to be, you know, more cost effective than the alternative examinership. So therefore, it is envisaged that the process advisor will be able to do pretty much all the work by him or herself and their team. And again, too, on that point, exactly, because that's just the process advisors to use, and as much as he or she can, you know, the company's employees and all that to do the work to keep down costs, you know. So at the end of the day, yes, it would be, like Sinead said, experienced insolvency
Yeah, and I
practitioners.
suppose on costs, like the circuit court will have an oversight on the costs incurred by the process advisor along the way. So it is open to a member or a creditor to review the process advisor's costs, and maybe if they don't like what they're seeing, they can make an objection. I suppose the downside of that, you know, and I suppose it's to prevent people from making objections willy-nilly. So if a court finds that the objection isn't a valid one, they can award costs against the member or the creditor bringing the objection. So that's one to think about with caution, I think.
Yeah, absolutely. Well, we're almost out of time. Thank you. I think that was an absolutely super session, an awful lot in it, and as you say, new process, be really interesting to see how it goes. Can I just ask a couple of other questions which have just come in very quickly? What are the likely costs for this process? Any general?
Yeah.
Yeah, I suppose it's very hard to say. I mean, I think the process advisor, and David, you'll probably answer this better, will look at the statement of affairs initially and will be able to assess from that the complexity and what's going to be involved.
Yeah, I know that's a very difficult question to answer, like, and I'm not going to talk for every insolvency practitioner in the country on this webinar, but it goes back to even the question that Conal raised, like, you know, a lot of the work in reality will need to be done pre-coming to the process advisor, you know, so therefore in terms of this being an option and dealing with all the complexities that need to be dealt with, and that may be done in consultation with an insolvency practitioner before he takes on the formal process advisor role. But as you can see, the process advisor piece is very tight, so therefore it's envisaged the cost shouldn't be huge, you know, but again, as Sinead said, it depends on each individual case, looking at statement of affairs, the balance sheet, the complexities.
And if it's complex debt, and it depends on the time that the process advisor is going to have to put into this and the nature of the assets that they're dealing with.
Yeah.
So I think costs will vary very much case for case.
Sure. Okay, great. And can I just ask you about suppliers then and enforcing ROT, or retention of title? Where does ROT fit into this process?
Yeah, because again, too, like, you know, in terms of this process, like, because a creditor has retention of title, they have retention of title, and if it's valid, it's valid, and that can be proved, and everybody's satisfied with that. If that title over goods, the title over goods. So if, like, they're protected, stroke ring fenced, you know. So I suppose that's the whole thing of this, is to give, you know, you have to give the best outcome and not, you know, to prejudice any individual creditor's outcome. So if ROT is there and it's valid, you know, it's valid and has to be taken.
And secured creditors would come into that category as well. Likewise, you know, security isn't affected by this legislation. They retain priority.
So in practical terms, then, if there's ROTD, that you'll come into an arrangement with the creditor as to how you're going to deal with that going forward, and use it and pay for it as you're using it, cash up front, that sort of thing, from a practical perspective.
Okay, brilliant. Well, that was absolutely brilliant. I want to thank our panel for your prep and for answering all of the questions so completely. I think it's been really, really useful, and I think, you know, it's really a matter of keeping in touch with it, both on your own website and on the Technical Hub on the Institute website, and we will include a link to both of those when we send out the PowerPoints. So thank you again to the panel. Also want to thank Laura Michelle Moore in my own team, who helped with questions and prep, and to our fantastic program coordinator, Chris, who makes this webinar possible. So many, many thanks, and stay in touch with us. Thank you.